The different styles of probate administration. Hi, I'm Darren Findling of the Probate Pro, and there's a lot of confusion around these four concepts: supervised and unsupervised administration, and formal and informal probate. Let's understand this at a little bit deeper level. First, as it relates to informal and formal, it relates specifically to the manner in which you open the probate estate. Informal administration is done through an application to open the probate estate. Formal administration is done by petition. In an informal application, there's no court hearing. It is a proceeding that begins, and the register of the probate court either grants the application or denies it. If they deny it, it then has to become filed as a petition and go through the formal administration process. The idea of an informal administration is really designed when there's family harmony or when the person with the highest order of priority has been nominated as the personal representative. For example, the person identified or nominated in the will, or maybe the surviving spouse in an intestate administration. That means without a will. That person has the highest order of priority and can get appointed by the probate court through an application for informal probate and an informal proceeding. On the other hand, a petition for probate is done with the necessity of a court hearing in front of a judge, and there's an adjudication as to whether there's intestacy or testacy, that means will or no will, as well as the formal appointment of a personal representative. Now let's understand the difference between supervised and unsupervised administration. The general concept is that the court wants families to administer the probate estate with as little court involvement as necessary. So you can proceed with an unsupervised administration unless the will specifies that there must be supervision of the probate court, or any interested party asks the court for supervision. In an informal administration with no supervision, that proceeding occurs primarily on paper, and there are minimal filings to the probate court. For example, after the application, the inventory has to be presented, and then at the end, a closing statement needs to be filed. On the other hand, in a supervised administration, each step of the probate process requires a filing with the probate court, and the court maintains jurisdiction of the issues. So in a supervised administration, that is typically recommended when there's disharmony among the interested people in the probate estate, or there's complicated issues and the court is going to be more involved. So if you're a person involved in a probate administration and you have the choice to whether proceed informally versus formally, or unsupervised versus supervised, you have to really ask yourself whether you are confident that the person serving as personal representative is trustworthy and whether there's going to be a need for the court intervention. Allowing a personal representative to proceed informally and unsupervised creates great risk because there's not a ton of accountability. For example, there's no bond in place when real estate is sold. There's no proceedings that occur for annual accountings, such that the court is constantly holding the process and the people involved in the process accountable. So we strongly urge you to be very careful about these situations and work with a skilled, competent probate practitioner. If you have any other questions about probate, visit us at theprobatepro.com or call us at 1-833-PROBATE.